our nation, and in particular this committee. We ask for your guidance. We ask that whatever we say and do today will be in the best interest of all of us. We ask for journeying mercies for those who are on their way, and we also ask for journeying mercies when we shall have left this meeting. These are another mercies we ask in your name. Amen.
Thank you, member. Apologies for absence. We have apologies from member Golden, member Cuthbert Flynn, member Fraser Binns, member Wheatley, member Scott Motley, member Julian Robinson. Apologies as well for Mr. Bailey from Legal Reform. And I believe Ms. Dalrymple Philibert is on her way. So welcome again. You should have gotten in your email a copy of the minutes and a summary sheet of the decisions made by the committee. Again, it goes from clause 1 to 28. But if you look at the last page, clause 28. Yes, sorry. Clauses 1 to 28. And for today, we're going to begin on clause 29. But before we get there, we will do the reading and confirmation of the minutes for the meeting held on October 3rd, 2019. While you contemplate the minutes, let me just welcome Office of the Parliamentary Council, Attorney General's Chambers, Legal Reform Department, Ministry of Science, Energy and Technology, and to say today we have a new committee chair. She's sitting in for Ms. Cheshan Brandon, and her name is Grayson Morrison, committee clerk. Yes. Yeah, Grayson Morrison. How do you spell that? So in the minutes on page 3, the last paragraph, the sentence beginning with, he said there should be contemplation of the business model and the enforcement of collections of hundreds of persons would potentially need to pay a registration fee. Page 3. That sentence does not read well. Kadian was not here. So it said, Member Roberts, just to read from the top so we get the sense of it, Member Robinson inquired the international models that were researched and the approach that was taken. He said the scope and breadth of persons that fell under the legislation would be far greater than the existing regulators, as the Act creates a unique scenario. He said that there should be contemplation of the business model and the enforcement of collections. Instead of that should be probably as hundreds of persons would potentially need to pay a registration fee. But I don't know about the hundreds of persons, so if anybody can recall. No? Okay. I would change it off to as to so that the sentence will read better. On page 5, second to last paragraph, clause 22(7)(a), it was contended that whenever the information was necessary for a legal obligation, the data subject was not to be provided the required information even after the information was recorded. Should be a legal obligation or for security reasons. Page 5 of the minutes, second to last paragraph, where it begins clause 22(7)(a). And it's the provision limits the rights given in clause 22(7)(b). It is saying it was contended that whenever the information was necessary for a legal obligation, the data subject was not to be provided the required information, even after the information was recorded. Would it be a legal obligation or for security reasons? You want to think about that for a little, Ms. Maria? We can recommit the minutes if you want. Go ahead.
Chair, on page 5, in the last paragraph, the second to last line, where it says prescribed would mean prescribed in or under the regulations, that should be prescribed in the act or under the regulations. 5 in the last paragraph, second to last line. No, where it begins with clause 22(8), the second to last line of that paragraph. Yes.
It's printed differently for different people.
Yeah. Well, it's the paragraph beginning clause 22(8).
Could you repeat, please?
In the second to last line where it says, Ms. Grant explained that by virtue of the Interpretation Act, prescribed would mean prescribed in or under the regulations. That should be prescribed would mean prescribed in the act or under the regulations.
All right. And then just a couple of edits. Clause 24(6), the last, second to last sentence, where it begins, Ms. Murray expressed that the ministry was unclear why the next one. Ms. Murray said that sufficient reason was not given why a data subject could not to withdraw consent. I think the two needs to be taken out. Could not withdraw consent. And then on clause 25, the very first sentence where it says that Ms. Murray explained that the second standard provided that personal data should be obtained only for one or more specified and lawful purposes and should not be further processed. I would take out further. It should not be processed in any manner incompatible with those purposes.
Chair?
Yeah.
In relation to clause 22(5)(a), where it says the third line from the bottom of that paragraph.
22(5)(a).
Well, the fourth line from the bottom. Ms. Grant explained that the data controller could process data without authorization and would only be obliged to disclose it to the data subject in the event of a disclosure to a third party. It would be, that should be, instead of authorization, without disclosure. So it would read, Ms. Grant explained that the data controller could process data without disclosure.
repeat where it is, Ms. Grant? I don't see that.
Clause, the provision, the paragraph dealing with clause 22.5a.
I don't see that.
It's my page 6.
Sorry, I don't see that on my page. 5A, 22, 5A. This 6. 22, 5A. Oh, okay, all right.
Right, so
Okay.
where it says the data controller could process data without authorization, that should be without disclosure.
All right. And then finally from me, clause 26, the third standard, very first sentence, Ms. Murray said that personal data should be adequate, relevant, and not excessive in relation to the process for which they were processed. I think that process should be purpose. See?
Thank you, Chair. With respect to the query on page 5, yes, that is correct, but just for clarity, what we're talking about here in terms of the information that the data controller would not be required to give, it's the information in relation to, let me just find it. It's the information required under 22.6, which treats with the identity of the data controller, identity of the data protection officer, the purpose for which the information is to be put, etc. So that is what, if there is a legal obligation on the part of the data controller to provide that information, then he doesn't have to he or she or it doesn't necessarily have to provide that information at that time.
All right, thank you. If there are no other corrections for the minutes, I put it to the committee to confirm the minutes. Confirmed by Member Morrison, seconded by Member Charles. Are there any matters arising from the minutes? Okay, if there are no matters arising from the minutes, we will begin today's committee meeting at clause 29, the 6th standard. Ms. Murray or Ms. Smith-Newton? Ms. Murray.
Just one point, Chair. At the last meeting, a question was raised in relation to public interest definition. The ministry did some research around that. We couldn't find any jurisdiction that uses the term public interest that has also defined the term in its legislation. And we, in discussion with the Attorney General, representatives of the Attorney General's chambers, we were advised that they too did some research on this particular matter and were unable to find any jurisdiction that defines public interest in the legislation itself.
Sorry, just to add, though, Chair, that generally the term public interest is left to be decided by the courts in the particular circumstances of the matter. So when you decide to define it, you could unduly restrict its application. The term public interest is used throughout Chapter 3 of our Constitution, which deals with our guarantees, our fundamental rights and freedoms. In fact, in the older version of the Charter of Rights, it was used even way more extensively. And again, it was never defined. and it's usually left to case law to determine how you apply the public interest to the particular circumstances.
So, Chairman and members of the committee, continuing, there were no comments received from stakeholders on clause 29 of the bill.
So I put clause 29 to the committee. If there are no objections, we move on to clause 30, the 7th standard.
With respect to clause 30, the 7th standard, the standard is that appropriate technical and organizational measures shall be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. And measures shall be taken to ensure that the Commissioner is notified without any undue delay of any breach of the data controller's security measures which affect or may affect any personal data. And it goes on. We had 2 comments from stakeholders in relation to clause 30, one from the Jamaica Computer Society and one from the Office of the Director of Public Prosecution. And essentially, both stakeholders have said that the provisions here in clause 30 could be a little bit more robust. They appear inadequate, and we were recommended to consider by the Office of the Director of Public Prosecution the UK Act and the GDPR Article 32. So you will see in our comments from the Ministry that we agree that there could be greater clarity given to this particular standard with respect to the technical and organizational measures, and we recommend to the committee that it could consider the language used in either the UK Act of 2018 or the Article 32 of the GDPR. Just to say with respect to the GDPR that essentially it goes into some of the matters that data controllers will be required to consider as they implement technical and organizational measures, and these include encryption of personal data, the ability to ensure ongoing confidentiality, integrity, availability, and resilience of the processing system, the ability to restore the availability and access to personal data, and the regular testing, assessing, and evaluation of the effectiveness of their technical and organizational measures. So it goes into a little bit more detail than we currently have in the bill, and so we put that to the committee for consideration. The committee is also asked to note in relation to a comment from the JCS that there is no need to inform the data subject of a breach under this standard, as a requirement for notification of the data subject is already addressed in clause 21. So members will see in clause 21, subclause 3, that an obligation has been placed there for data controllers to report to the Commissioner without undue delay any contravention of the data protection standards and any security breach in respect of data controllers. And they're also required to report that to the data subject as well.
2 questions, Chair, if I might. Firstly, the Article 32 of the GDPR, what we have here are the aspects of that which you think are, and I'm looking under the heading research findings. These are the 5 elements that you think need to be added to our clause, right? This is not the actual, correct? So the only concern I had is when we have completed the actual drafting and inclusion of these things into the clause, do we, well, perhaps I'm just highlighting whether or not there may be terms that are added that require any form of, definition or terms of art or otherwise, because there are things here which, perhaps might require us to look on the definitions. Secondly, the clause 21 that we referred to, could you guide me? I'm looking on the page 74 in the matrix. I just want to be guided to exactly where in clause 21 that you have the requirement for notification of the data subject.
So,
being treated with.
in response to the member, the ministry certainly doesn't believe that there are any terms used here from Article 32 of the GDPR that would require further definition.
Okay.
But we will certainly rely on our colleagues from the CPC, or the Office of the CPC rather, to guide us in relation to that. And I suppose if we have to come back to the committee on that, then we would do that. But on the face of it, we certainly don't see any particular challenge with the terminology or terms that are currently stated in Article 32. With respect to my reference to my apologies, Clause 21.3, I was actually referring to not the matrix, but the actual bill.
Okay.
So, if members have their bill, that would be on page 31 of the bill, where it's laid out that security breaches should be reported to both the data subject as well as the commissioner, and that's clause 21, subclause 3 and subclause 5. So clause 21.3, for the benefit of the members, a data controller shall report to the commissioner without undue delay any contravention of the data protection standards and any security breach in respect of the data controller's operation which affects or may affect personal data. And then subclause 5 says, where a contravention or security breach mentioned in subsection 3 is likely to affect a data subject, the data controller shall, without undue delay, notify the data subject of the nature of the contravention or security breach, the measures taken or proposed to be taken to mitigate or address the possible adverse effects of the breach, and the name and address and other relevant contact information of its data protection officer.
So I put clause 30, the 7th standard, to committee members with the recommendation of the ministry that greater clarity could be given to the technical and organizational measures, and the recommendation that similar language to that adopted by the GDPR and the UK's 2018 Act be used. Okay. So if there are no objections, we will accept clause 30 with the recommendations from the ministry. We'll move on to clause 31, which is the 8th and last standard, is that personal data shall not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights and freedoms of data subjects in relation to the processing of personal data. Ms. Murray.
Thank you, Chair. So we had several comments from stakeholders on this particular clause, and I will just take the members through those comments and the ministry's response to these. So with respect to clause 31.1, the Jamaica Bankers Association indicated or commented on the fact that they thought that guidance on what is adequate protection and how it will be determined if a state or territory has adequate protection needed to be included or delineated in the bill itself. Members will see or comment that the legislation already as it is contains guidance as to how the commissioner and or minister, as the case might be, would be able to determine whether or not a country, and a third country or territory, has met the requirement of adequate level of protection for rights and freedom of data subjects. And in that regard, members, your attention would be directed to 31.2, which says that for the purpose of subsection 1, which was read by the chair earlier, an adequate level of protection is one which is adequate in all the circumstances of the case, having regard in particular to the nature of the personal data, the state or territory of origin of the information contained in the data, the state or territory of final destination, the purposes for which and the period during which the data are intended to be processed. Importantly, the law in force in the state or territory in question, the international obligations of that state or territory, any relevant codes of conduct or other rules, and any security measures taken in respect of the data in that state or territory. So in our minds, clause 31.2 outlines certainly the factors that would be taken into consideration when determining whether or not a third country or third country, state or territory has adequate level of, or maintains an adequate level of protection as it relates to the rights of data subjects. So Digicel also had a comment with respect to clause 31.1. They suggested that legislation provides a predetermined list of states or territories that meet this section or requirement in order to provide greater certainty to data controllers. They noted that if this is not possible, an amendment an amendment is recommended to this section to provide a specific turnaround time in which the commissioner is required to respond to a data controller's request for a determination of whether or not a state has met or has adequate levels of protection for personal data. In relation to clause 31.4, the comment from Digicel was that the legal ground mentioned in this section for the transfer of data outside of the jurisdiction is ambiguous, and I'll just read what 31.4 says. So 31.3 first says that the 8th standard does not apply to a transfer falling within any of the cases specified in subsection 4. And then in subsection 4, it gives a list of instances where a data controller could act without needing to determine whether or not a particular territory maintains an adequate level of protection. And those instances or circumstances include where the data subject has given his consent to the transfer is necessary for the performance of a contract, or taken steps to give effect to a contract or enter into a contract. Transfer is necessary for reason of substantial public interest. Transfer is necessary for the conclusion or performance of a contract. In relation to the transfer is necessary in relation to any legal proceedings. The transfer is necessary in order to protect the vital interest of the data subject. The transfer is part of the personal data on a public register. And the two last one, transfer is made on the terms which are of a kind approved by the commissioner, and the transfer has been authorized by the commissioner as being made in such a manner as to ensure adequate safeguards. So in those instances, there need not be any determination of whether or not the territory maintains an adequate level of protection. So Digicel further recommended in relation to 331 subclause 4 that an explicit provision should be inserted which states that transfers are permitted where there are contractual clauses between the controller and the recipient of the personal data in the third country where such clauses are legally binding. And they further suggested that an explicit provision be made to facilitate international intra-company transfers between members of the same group or corporate group, so that if there's a situation, several companies in different islands, for example, then they would be able to transfer data within those their outlets or companies in each territory without having to concern themselves about the adequate level of protection of each state in which they operate. Just to share with the committee that there were several comments similar to that. That was from ALAI had a similar comment. The U.S. Chamber of Commerce had a similar comment, and so too did the Jamaica Chamber of Commerce. All of them recommending essentially that provision be given to allowing contractual clauses to determine how persons transfer data rather than relying on a determination as to whether the country itself maintains an adequate level of protection. Or comment and response to those stakeholders that would have raised that as an issue or recommended changes to that effect. We note all the comments recommending the inclusion of what is essentially a corporate contracts clause, which would exempt transfers made regularly as a part of a business from the 8th standard, where adequacy is determined based on the terms and conditions in the agreement. In response, the Ministry concurs with the comments and recommends for the committee's consideration the scheme as reflected in Article 28.3 of Malta's Data Protection Act of 2002, which provides that the Commissioner may authorize a transfer or a set of transfers of personal data to a state or territory that does not have the adequate level of protection, provided that the data controller provides adequate safeguards which may result particularly by means of appropriate contractual provisions. On. So that will take care of members' Digital's comments, ALAI's comments, the U.S. Chamber of Commerce, and the Jamaica Chamber of Commerce. With respect to /roots, they sought clarification as to whether section 31 subsection 4H and I, and I would have read those instances where the transfer is made on terms which are of a kind approved by the Commissioner, or the transfer has been authorized by the Commissioner. They sought clarification as to whether those two subclauses relate to the Commissioner approving on a case-by-case basis if data can be stored outside of Jamaica, if the Commissioner deems it is more adequate, if he deems it more adequate than stored in Jamaica. They went on to say that SMEs must be able to select the most cost-effective approach while also adhering to off-island redundancies, considering that our geographic location is known for hurricanes. There are better options and more adequate and cost-effective data storage solutions in other territories is a point. So with respect to the comment from /root regarding the rights of the data subject and ensuring adequate safeguards for rights and freedom, we note that ensuring adequate safeguards for rights and freedom of the data subject does not equate to the data subject being granted carte blanche access to data. On the contrary, the provision seeks to ensure that the rights and freedom provided to the data subject under the bill will be protected when the data are transferred to the third party state and territory. So the concern here is that the bill is not seeking to restrict persons in terms of where they, for purposes of redundancy, or store their data, but simply that if you're going to consider storing your data somewhere, you must store your data where the data subject's data will also be protected, hence the need for demonstrating that either one, the country itself meets the adequacy test, or that you fall within the exceptions, and or, as we're recommending to the committee, there are contractual clauses which would protect the data subject.
Despite the circumstances of the territory, despite this territory not having, are there any jurisdictional issues that can arise if there's any conflict in terms of persons having issues with how their data is treated with? Because if the data is on some basis of a contractual agreement, but it is in a territory that does not have the adequate provisions, is the ministry in any way concerned about the potential jurisdictional issues that could arise?
So what we anticipate will happen, and yes, because we're sure that there are countries that, notwithstanding those contractual arrangements, would by their laws dictate to those companies, yes, that information should be revealed. But what we anticipate data controllers will do is, in determining whether or not they should be entering into an arrangement with that, those things need to be revealed in the first place. They need to understand the jurisdiction, the laws of the jurisdiction in which the, let's call it a hosting provider, for example, what laws govern then, and then they need to determine whether or not they're going to be compliant with the Data Protection Act if they enter into an arrangement with that particular company. So the onus is always on the data controller to inform itself of what the obligations are, legal and otherwise, of anybody who it enters into an arrangement with in relation to the data subjects, the protection of the rights of the data subject. The fact is that he couldn't enter into that contract and then say, oh well, but this is what is allowed. He needs to inform himself because he has an obligation under the legislation.
We're opening up that track in the legislation by leaving it to contractual agreement only, right? We would be opening up the option.
What would happen is that those contractual clauses would still have to be considered by the commissioner, because the commissioner could rightly say and ask and request that he or she sees those clauses to determine whether or not they will stand scrutiny. The fact is that if a company in a third jurisdiction can't guarantee or can't say in a contract that they are going to give you the protection or that you require for your data, for the data subject's information, then that clause wouldn't fall within what we're proposing here as protection.
I mean, this is one of a number of standards, so it can be seen in that way as well, right? In totality and in context. But I mean, I just voice my concern. But if the ministry is not concerned and can satisfy the committee, my concern really just flows from my initial response to what you said in terms of contractual agreement in a territory that itself has no adequate local legislation, and what jurisdictional issues could flow. If there's none, if you're saying there's no great concern, then move forward.
I don't think we're saying that there is no concern. What we're saying is that if a data controller is to transfer or proposes to transfer personal data of Jamaicans to a third country, and the person with whom they have entered into a contract with cannot, on the terms of those contracts, provide for its protection because of laws they have that would mitigate against that, then the data controller here ought not to enter into that contract and could not rely on that contractual clause as an opt-out of this particular standard. We appreciate that there are countries that, because of the laws of those lands, even if you enter into a contract, there may very well be a clause that says, or a notification to the effect that, listen, my government can, through law enforcement, access the information. But that's something that needs to be said. That's something that our local data controllers would need to know, and then they would have to assess, is our point, whether or not they're going to be transferring at all data to that particular jurisdiction. And they certainly, in our estimation, could rely on a contractual clause, because that contractual clause would be of no moment and could not be legally enforced.
Could not be legally enforced.
Okay.
I just...
Member Whittle?
Yes, the comment made a while ago about that those contract clause could not be legally enforced. How would you be able to say that? I'm just trying to find out, because if you have a contractual clause, then why couldn't it be legally enforced?
In relation to the jurisdiction that doesn't have the law?
Right.
Because there will be conflict. That's what I was saying.
Yeah,
if you have a state or a country where they do not have the law, or they have some contradictory law, then your contractual agreement might very well be some conflict if there arises a legal dispute as to how to examine the matter. But I gather that what the ministry is suggesting is they don't suspect it would reach that stage, because the data controllers ought to have examined it and ought to know who, or at least what territory they are engaging with, right?
But what if they don't do those due diligence?
That's the question that I was asking. What if?
What if they don't?
They don't know?
If they don't do the due diligence, because...
We're still leaving it open.
Data controller has an opportunity, an obligation to investigate.
I would say, Madam Chair, you would have an obligation if you're going to do that, and you're planning to transfer. The first thing you need to do is what is the status of legislation in relation to that in the country that you want to transfer to. In that case, you know that you can't, because if you do, you don't have protection.
So, and that is one of the recommendations from the ministry, that the commissioner determines whether a state maintains an adequate level of protection in like manner. Right, so that would be an amendment to the clause.
We, however, Chair, are not going to provide, as I see in the comment from the Jamaica Bankers Association, and I think from another comment, any guidance on the states that have adequate protection. That's not something that we're contemplating as, let's say, or are we doing so? It
is contemplated in the standard that would be determined.
No, meaning it appears.
But
that
no, not now in a list. Not now.
Okay.
Not as of. But it is contemplated that the minister would issue an order to that effect.
At some point.
At some point.
So that would be useful and would assist, I think, with Member Whittle's concern and also my concern.
Just wanted to share, and I think we would have said it in the, I think, maybe at some other point, but even with respect to prior to the GDPR, and our research revealed that maybe 10 to 12 countries were actually identified by the EU as having or maintaining an adequate level of protection. I just want to share with members that 10, just 10, and even in its relationship with the EU's relationship with the US, the USA, for example, wasn't determined as a country that has adequate level of protection, but a separate arrangement had to be entered into in the form of a privacy shield agreement. So it's an assessment that would have to be done, and the standard contemplates that the minister would do that. So the request rather that this list be determined now and included in the bill, we're not there yet. It would require some review and research, and a commissioner would certainly help the minister in that regard. But as we're saying, there are other circumstances listed there that a data controller could operate within or under without needing to rely on the adequacy provisions or adequacy or determining whether the country in and of itself maintains an adequate level of protection. And that's because, as we said, there's a contractual relationship, there are legal proceedings happening and so on. So those circumstances are exceptions rather to the general rule that you must first, if you cannot transfer to a country if it doesn't maintain an adequate level of protection.
All right, I put to the committee clause.
Sorry, Chair, I just need some clarification as to the proposed amendment, because I'm not sure why that the proposal that was made would not be thought to have already been covered under subsection 4H, which provides for the commissioner to approve the terms on which a transfer is being made to ensure that there are adequate safeguards for the rights and freedoms of data subjects.
While, Chair, it's something that could be implied from that, we thought that because there were so many stakeholders that did not read the contractual clauses into as a part of that particular H and clearly wanted to see explicit language along that line, that it would do no harm to have an amendment that included or referenced contractual clauses.
All right, members, I put clause 31, the 8th standards with the recommendations from the ministry. In terms of the ministry, one, recommending that the commissioner determines whether a state maintains an adequate level of protection in like manner, and whether or not the commissioner would accept the corporate contract. Go ahead.
Right. Chair, to the members, just want to be absolutely so that the members understand the amendment that is being proposed in relation to the ministry's recommendation that the commissioner determines whether a state maintains an adequate level of protection. At present, it is the minister that is designated in the bill, and we're saying that that could be something that the commissioner could be charged with doing rather than the minister. So we put that, just want to be absolutely clear, because we don't want what we've seen across some of the jurisdictions is actually that most jurisdictions allow for their commissioner to do that determination and not their minister. I think the Secretary of State in the UK, who is our equivalent of a minister, is one minister that is allowed to make that the legislation allows him or her to make that determination, but primarily the activity is carried out by the commissioner. So we put it to the committee, but we want to be absolutely clear. We just want members, we don't want members to leave with, as well as Bermuda.
Can you hear me? Because if it is that the law says that the transfer, as the Madam Solicitor General did say, that it's on the terms approved by a commissioner as ensuring adequate safeguards for rights and freedoms of data subject, wouldn't that cover the mischief that has been raised by whoever has raised it? Because if you're acting with consideration of the rights and freedoms of data subjects as outlined in statute or outlined in this bill, then why would we need to add additional? I'm asking. Rights and freedoms cover what needs to be covered?
Member, can I ask you to just repeat so that I'm sure what question you're asking, so that when we give a response.
All right, so so the question is that, in my estimation, whether or not there is proper safeguards to protecting the interest of persons whose information may be requested by an external power or another country. Is that a correct phrasing of what the question is?
So, I'm not going to answer your question directly because I'm not quite sure where you're going, but I'm going to say this, what we're trying to do here with the standard. The idea of the standard is this, that Jamaica will have a Data Protection Act which seeks to protect personal data of its citizens. And a data controller, Jamaican, is by this standard being told essentially that you cannot transfer personal data in relation to data subjects to a third country that does not offer similar or like protection in relation to personal data. So that's the general principle, and then it goes into some exceptions. And those exceptions, as itemized here, including H and I, is that the transfer is approved and authorized by the commissioner, because the commissioner determines that the mechanism that is being used to transfer and that the rights of the data subject will not be infringed when it goes to that third country that does not offer a similar protection. And that's because we're assuming there are contractual arrangements and or otherwise in place that would say if there is a breach, then there is recourse, because the issue really is around, is there recourse? So the transfer is made on terms which are of a kind that is approved, which could be the contractual clauses that we referred to, or is authorized by the commissioner, because the manner in which the thing is being transferred, and we spoke about, for example, a group of companies, whether it's a Scotiabank or a Digicel or whatever, that has multiple subsidiaries in different countries transferring data among themselves, or among itself rather, in these, on those bases. So there is the contractual arrangements that can be done. There are also rules-based conglomerate type arrangements that can be put in place, and what H&I are basically saying is that those arrangements would have to be assessed by the commissioner, and the commissioner would have to determine that those arrangements will offer the protection to the data subject. So I'm hoping, member, that from that I've answered what we're trying to protect.
Understand.
All right, I put clause 31 with the recommendations and amendments to the committee. If there are no objections, we accept and move on to part 4.
I'm sorry, Chairman, but the ministry is trying to do two things. We would have submitted our matrix, and members will recall that it received 2 volumes from the House itself. And we want to ensure that we remain true to both sets. And we have found that there may be 1 or 2 instances where our matrix did not have a comment from a stakeholder, and we want to ensure that we address all the comments. So we're going to ask the members to indulge us a little bit as it relates to clause 31, because there were 2 comments that we didn't, weren't reflected in our matrix. One from FID, the Financial Investigation Division, and 2 from ALIA. On clause 31, the FID indicated that the clause is particularly problematic, or would prove problematic for them, as they may not always be able to analyze the level of protection for rights and freedom of data subjects offered by a territory, a third country, in the performance of their own duties, bearing in mind what it is that the Financial Investigation Division does. So there was a concern from them in relation to that. There was also a concern from ALI. Well, there was 2 proposals from ALI. They proposed an amendment to the standard, it's the 8th standard, to effectively read the 8th standard is that the personal data may be transferred to a state or territory outside Jamaica according to the nature of the service. So they were proposing an amendment to clause 31, subclause 1. And then they proposed another amendment to clause 31.3, and clause 31.3 essentially to delete the requirement to consult with the commissioner. Clause 31.3 reads the 8th standard does not apply to a transfer falling within any of the cases specified in subsection 4, except in such circumstances and to such extent as the minister may prescribe after consultation with the commissioner. With respect to ALIA's proposed amendments, the ministry doesn't support either of them. That's the amendment to 31.1 and the amendment to 31.3. And that's because as it relates to 31.1, we think that the proposal they have, that is that the 8th standard be that the personal data may be transferred to a state or territory outside of Jamaica according to the nature of the service, significantly changes the standard. It really opens up transfers to everybody, which what we're trying to do is to ensure protection and that there is an adequate level of protection being offered by states to which data controllers may transfer data. And then with respect to 31.3, we wouldn't support the exclusion of or the deletion of the requirement to consult with the commissioner, because we do believe that the minister should consult with the commissioner when trying to determine circumstances other than those itemized in subclause 4. With respect to FID's concern, we note, but we weren't able to investigate outside of the UK, that the UK has in their section 73 provisions that deal with law enforcement, transfer for purposes of law enforcement. And it's something that we would crave the indulgence of the committee to investigate a little bit more so that we could come back to them, to the committee, on how to treat with the concern raised by FID. And I suppose other law enforcement agencies would have a similar question as to how to treat with transfers they may make for purposes of law enforcement.
Right, but I thought earlier on you said the commissioner has the obligation to ensure that the territory has like laws, and if they're not, the commissioner can still make a ruling, right, as to whether or not the data can be transferred depending on the contractual obligations.
True, Chair, but and I don't want to, I'm going to put myself in FID's shoes a little bit and speak for them. I think their concern is that in light of the work that they do, they would be hamstrung in having to go to a commissioner for a commissioner to be clearing and determining adequacy in light of what they particularly would have to do.
Mm-hmm.
So,
but Ms. Murray, couldn't there be pre-clearance of countries? Wouldn't the commissioner have a list, though, of countries? I mean, there are what, 100 and...
So, Chair, the concern here is that they may transfer to, let's say we had a list. I don't want to call any particular, but a country A is not on that list. But there is an arrangement between law enforcement agencies that they would share information. Then if that country is not on that list, I think what the FID is saying, they would have a problem, because on what basis, certainly if something isn't stated in the legislation, on what basis would they be sharing that data? And as it is, having reviewed the legislation, the bill, they're not seeing where they could continue to share information with law enforcement in other countries if that country isn't designated as having an adequate level of protection. And as I indicated, Chair, we looked at Section 73 of the UK Data Protection Act of 2018, and they went into a very elaborate, they have an elaborate set of provisions in relation to law enforcement alone. So we wanted to do some further investigation on that, because we see it as a particular concern that would require the committee to address it, because we wouldn't want a situation where law enforcement agencies are unable to carry out their duties because of provisions here. So on that particular matter, Chair, while you're putting clause 31 to the committee, we certainly didn't want to leave any issue unaddressed, and particularly one as sensitive as that.
All right, so on clause 31, committee members, I put that to you in terms of the recommendations the ministry is making, in that the commissioner and not the minister would determine whether a state maintains an adequate level of protection in like manner. the adoption of the scheme as reflected in Article 28.3 of Malta's Data Protection Act of 2002, and the ministry is asking as well to come back to do some further research and come back with regards to the concerns raised by FID.
So we're going to accept the clause still?
Well, the recommendations, but right? Two different things.
Isn't it referring to the same 31? Yeah. So does it accept, does it have any, impact on whether we ought to accept that clause?
No, I'm putting the recommendations as we have them here for clause 31, and there are two recommendations. One would be for there to be a change in the bill from the minister to the commissioner to determine whether a state maintains an adequate level of protection in like manner. And with regards to a group of companies that operate in different states, different countries, for us to adopt this scheme as reflected in Article 28.3 of Malta's Data Protection Act of 2002. So those are two matters that the committee can accept, but also the ministry was asking for time to do more research into the issue that the FID raised as it relates to law enforcement and their ability to share data among countries and not have to wait for the country to be put on a list as determined by the commissioner.
The minister who you're trying to banish, wouldn't he or she, my apologies, wouldn't he or she be guided by the data commissioner? Is there any benefit to having the minister there, not just the data commissioner? What about the other jurisdictions where there is that overarching body or person who is being guided by the data commissioner or the relevant person in a similar position? Why are we reducing it to what would be perhaps somebody at a lower level? Just asking. I'm trying to say, what mischief are we trying to remedy by removing the minister? Is there some effort or some thought that it might impede the process, or they don't have the right competence to do so? What's the basis? Because we're always just removing ministers. I'm just wondering why. SG?
What we've seen when we reviewed the various jurisdictions is that this responsibility of sitting to determine and going through laws to determine and looking at jurisdictions, laws and otherwise, treaty arrangements also, to determine whether or not that country is adequate, is an activity that is carried out by the commissioner. So what we're simply trying to save the minister from trying to do is to having to exercise his mind around that. We appreciate that the commissioner would be relied on to do that work. But it's administrative. We're just, the recommendation was made simply because of what we have seen and how we see other jurisdictions doing it, with very few jurisdictions placing that responsibility on ministers. And so we put it to the committee for consideration.
Can I ask the SG for her opinion? Solicitor General, do you have an opinion in this regard?
I'm just clarifying if it was 5C in particular. Right, so we don't support removing the power given to the minister to prescribe. That's a matter for the executive. It's an administrative arrangement how the minister undergoes this activity. And there's a principle called the Carltona principle, which is our case. where it says wherever you see minister, it doesn't always mean that the minister is the only one who's going to be undertaking the powers and functions, and what goes behind being able to execute those powers and functions, because it would be impossible. And so we don't talk about delegation. What we talk about, though, is that there are other functionaries that will do some of that background work. So it's always understood that when you say minister prescribe, and in our jurisdiction, we have the executive undertaking that kind of power, but there is usually administrative support to assist the minister in how she or he may undertake that function.
So my queries have some value. Yes. So perhaps, well, it's a matter for the committee anyway. Chair? Right? It's a matter for the committee. You're just putting it to the committee. So, I know. I don't mean to make it sound like that, but I really don't see why we're removing the minister, or why we would want to, so I wouldn't support it. Not sure the other committee members.
Committee members? Okay. Yeah. Okay, so then the bill stays as is with regards to that particular entry. And the other recommendation would be the adoption of Malta's data protection, the Article 28.3 of Malta's Data Protection Act. So, no, we're still on 31, trying to get from the committee members. There no objection to adopting this Article 28.3 of Malta's Data Protection Act, which provides that the Commissioner may authorize a transfer or set of transfers of personal data to a state or territory that does not have the adequate level of protection, provided that the data controller provides adequate safeguards, which may result particularly by means of appropriate contractual provisions. Okay, so we accept that recommendation from the ministry, and the bill remains as is with regards to the other recommendation that the commissioner would determine whether a state, it remains with the minister, and we would give the ministry some additional time to do the research as it relates to the issues raised by FID in terms of their obligation or commitment to share data with other states that may or may not have adequate data protection. All right, so we move on to Part 5, exemptions to data protection standards or to disclosure to data subject requirements. And we would begin with Clause 32.
So with respect to Clause 32, we had one comment from the Financial Investigations Division in relation to Clause 32.2. They note that this section, when read along with another section 67, will prove problematic for them. The provisions have the effect of negating any provision of any other statute or rule of law which prohibits the disclosure of information. They know that Section 97 of POCA will be negated by the operations of these sections, that's section 67 and 32, and then they go into what section 97 of the POCA speaks to. They mention that it is a tool they use to fight against crime, as it prevents persons from making disclosures which cause a subject to be tipped off when there is an investigation, and this can have a detrimental effect on, of course, their investigation. They recommend that the section be amended to prohibit disclosure that would qualify as a breach of section 97 of POCA.
How would this work practically? How does this, I mean, how would this work in a real life scenario, right? The concern that FID has is that the information might be exposed, correct? Am I correct? That's what the concern of FID, as they have articulated it here, is that the section could be problematic because what, the information will be exposed? But you're saying that...
So just to put it into context. So the disclosure of data subject requirements is what the clause is saying shall not have effect, notwithstanding any other piece of legislation. But the disclosure of data subject requirement is defined, and it's defined in clause 32(1). And essentially, disclosure of data subject requirement means or relates to the right of the data subject to access, which is section 6 of the bill, and section 22(6). And members will recall that section 22(6) is simply a list of represents information that must be shared with the data subject. And the information that is listed in 22(6) is information in relation to the data controller, the data protection officer, the purpose to which the data is going to be put, possible recipients of the data, and so on. So it's just information generally, or specifically in relation to 22(6). So when we say that the disclosure of data subject requirements shall have effect, what we're saying is that the data subject shall have a right to access, that's section 6 of the bill, or clause 6 of the bill, and shall have the right to be informed of certain things, notwithstanding any other rule or law, prohibiting the data subject having that information.
Yeah, well, you're saying that the investigations are exempt from that process.
So when we read, right, further, right, so when you look at, so the clause 32 is, I would say, a definition, it's a precursor to the rest of what comes in this particular part. Because as you go on, you'll notice in clause 33, as well as clause 34, that there are certain exceptions or exemptions generally to certain aspects of the legislation, and that would cover law enforcement in the context of prevention and detection of crime and apprehension and prosecution of offenders, and in the performance or discharging of statutory functions.
I have always had a concern with how legislation is developed and written sometimes. And let me tell you one of the concerns that I have. The FID has read this, and the FID's comment after reading the clauses is that they believe it might offend section 97 of the POCA. Now, that means that they went through, is it 97 or 60? 97. 97 of POCA. Am I correct? Yeah. So they went through this and did not draw the correlation between clause 622 and what is 34? Well, yes, 34.1. But we are expecting John Doe to do so. I mean, I guess it's a law as it is, but I say so because I'm hoping at some point, and it's not something that perhaps can be fixed here, but there's something challenging about how we are doing what we're doing if it appears so difficult that the Financial Investigation Division itself, in its assessment, didn't draw that correlation. That said, I understand clearly what you're saying. If it is exempt, then it wouldn't have the impact as they have commented. My concern stands. Years from now, there are persons who are going to read these laws, yeah? And this is no offense to who's writing them or drafting, because we are all part of the process. But is there any way to make it clearer, since it clearly wasn't as,
If I may, though, with respect to this issue, it does say, except as provided by this part. Those are the opening words. So it means that what is there applies except as otherwise provided in the part, and the part does provide exceptions. What could always be looked at is to ensure that the exceptions that are there fully capture what FID has said. That apart, I've been involved in this process for a very long time, and I can tell you that I recall really only in one instance a special effort was made for that legislation to be understood by the ordinary citizen, and that was the Charter of Rights, the new Charter of Rights. Because generally, we understand that certain types of laws, and this is not just in Jamaica, if you do the research, the laws are not meant to, they are meant to give effect to certain legal principles, some of them certain rights, some of them certain obligations, not meant to be ordinarily understood, even by those of us trained in law. That's never usually the first motive, and the only time I remember that being a huge objective was when we were doing the Charter of Rights. And you will notice in section 13.3 of the Constitution of Jamaica, we listed and set out the rights that are guaranteed to persons. And even then, anyone that wants to bring a constitutional motion still has to engage an attorney, not just to file the claim, but to even understand how you apply the Charter of Rights. So it's a complex issue when you talk about making a law reader-friendly, easily understood by the person in the street. What happens in a number of other jurisdictions is you have a law that is passed by the legislature, and then after that you will have a sort of little guide, a little book that is produced to assist. And that can be done as part of a public education campaign, and that is what a lot of other jurisdictions do.
If you may, Chair. Member Charles, am I to also understand that a part of your concern is that you want to see seamlessness, right, a level of seamlessness in the complete work? Yes, we may pull from other jurisdiction and it may sound good, but you have a concern as to the extent to which, one, it can become very applicable given our reality, and two, that we don't draw pieces of information, I'm just saying that, layman, and we have not entirely worked through the whole thing to ensure that one piece may not be in contravention of the other, and that it works in totality as a unit.
Well, yeah, yes, but I think what the Solicitor General said supports what I'm saying. And I fully understand that. I'm an attorney, so I know that, there are going to be complicated matters arising from reading and reviewing legislation. But we all here, I think everyone here agrees, particularly those who are trained in drafting, that we would hope that the law, as much as possible, can be understood. My concern is that I'm sure a person from FID who evaluated this was not just an ordinary citizen with an ordinary mind, but was definitely somebody learned in the law. And that was the concern that I said, that I raised, that if that person, if that person couldn't see it, then maybe there's something we need to look on, which goes back to what SG said, that perhaps it's just a matter of assessing the exemptions themselves. But again, back to the point at hand, the comment has been treated with, based on the exemption, Ms. Murray. So.
Yes, member. Essentially what we're saying is that clause 34.1 would treat with.
So essentially you're not proposing any amendment at all in this regard?
No.
Listening to what Member Charles has said, has the ministry had any consultations with the FID in relation to their comment and your response before we decide whether or not they would be satisfied with the answer that we have given? Would that be inappropriate, I'm asking? Because I wouldn't want for them to be of the view, even though we may have good reason to not agree with their view, that there is any attempt. I'm just asking if that is, through the chair, if that is an appropriate thing to do in light of their concern. I don't know, I'm asking.
I think if members, so in answer to your question, not whether this is it would be appropriate for consultation to be held with them, but generally no. Having received all the stakeholder comments, what the ministry would have done is to review the comments, review the legislation, and then respond to what the comments were. I think members though would appreciate, based on where we are now in reviewing the comments that we have made, that there are quite a number of stakeholders, certainly that from the ministry's perspective, as technocrats within the ministry, misinterpreted what was intended. We want to say this though, stakeholders would have been given a short window of time to respond when the request went out for comments. It is a 111-page bill, and it's a new regime. So we certainly cannot understand where there would have been misinterpretations of what is there. But no, we did not consult with anyone, and we certainly would hope that this sitting or the sittings of the Joint Select would provide that kind of clarity, and that people would be paying attention to the matters that are being discussed here. So that's just general. Now, how the committee chooses to treat with one stakeholder versus the 20 odd that came, I leave that to the committee.
Members, for clause 32, it is clear to me that the ministry is saying that there is no conflict with the provisions in POCA because there are exemptions as laid out in clause 22 for issues of national security, such as what FID has raised. And so I put clause 32 to the committee, noting the analysis from the ministry. There are no objections. We will accept and move on to clause 33. Clause 33. We'll move on to clause 33.
Yes, Chair,
That speaks to
my
national
apologies.
security.
We had indicated before that there are using the houses. Right, so this one, members, we actually didn't get the comments until after we submitted our matrix. So we didn't even see these comments from the Jamaican National Bank until late, until after we would have submitted the matrix to the committee. However, the Jamaica National Bank has one comment in relation to clause 32. They essentially want the basis of credit decisions made by financial institutions to be added to the list of exemptions. So that is the credit assessment and opinions. We've looked at, and for those members that may have this particular matrix, it's page 33 of 54, volume 1. We looked at the recommendation for inclusion, well, for exemption of the credit decisions, and we just wanted to remind the committee in relation to this particular comment that clause 12 of the data protection bill gives the data subject some rights in relation to automated decision making or taking. Clause 12 was agreed by the committee with only one change. The clause essentially enables a data subject, that's clause 12, to require a data controller to ensure that no decision is made solely on the basis of the processing by automatic means for the purposes of evaluating, for example, creditworthiness. So having granted a right by virtue of clause 12 in this way, this recommendation from Jamaica National for credit decision making to be exempt would be contrary to that right that has been granted by virtue of clause 12, which the committee would have supported before.
Question, Ms. Murray. Just on this, the parliamentary matrix, FID, again, they're there. I guess they've stated their case in a different way on the parliamentary matrix. They're saying the exemption is not adequate. The same clause, 32. Page 27 on the parliamentary matrix.
My apologies, Chair. It's picked up as well on 33. I think it might just be where the House placed their comment and where the ministry thought it was best fit. So, but it's captured.
The same? Okay.
Yeah.
All right. No, I thought 33, right?
So Chair, with respect to 32 and what is now in the matrix at page 102, I believe that you would have put that to the members, and I think that there was general support for what we had commented in terms of that their issue would be addressed by virtue of clause 34.1, but then I would have raised Jamaica National Bank's comments and or recommendation that credit decisions be added to the list of exemptions under this part, and I would have shared certainly what technocrats in the ministry think about that particular proposal, and essentially we're not supporting the exemptions, that exemption.
It's unnecessary. You say
Certainly not necessary.
Because it's already attended to by the section that treats with the decisions, the automated decisions.
Not necessarily in the context that it would be taking away a right which the committee would have previously approved. Essentially, that is the right that is given to data subjects by virtue of clause 12, which says that you can say to a data controller, do not process my data basically solely on the basis of, no, let me repeat, do not process or make a decision in relation to me solely on the basis of an automated decision. And they're seeking to exempt credit assessments and opinions on a credit report essentially in relation to a data subject. And what that would mean if you're exempting it is that the data subject wouldn't have access to that information, and we really can't see how a financial institution could be depriving a data subject of that information when it is that decision and assessment will impact.
Did they give any reasoning? Did they give any reasoning beyond, because I don't have the parliamentary thing before me. Was there a reasoning? Because simply basing it on what we had done before, I mean, I can understand the rationale, but what's the value in the submission that they have made? That should really be the point that we are looking on. Is there any reasoning?
I'll just, if I might crave the indulgence of the members to just read what they've said. So they note that the first data protection principle under the bill provides that personal data must be processed by means that are lawful and fair. Further, Section 6 of the bill gives individuals a right of access to their personal data. Under this section, an individual is entitled on making a request in writing to a data controller, such as a financial institution, to be informed free of charge whether his personal data is being processed by or on behalf of the data controller. If personal data is being processed, the individual is entitled to be given a description of the personal data in question, the purposes for which the data is being processed, the recipients or classes of recipients to whom the data is or may be Part 5 of the bill exempts certain processed personal exempts certain processed personal data from both the first data protection principle, with certain exceptions, and Section 6, which is the right of access. In particular, Section 34(1) exempts personal data processed to the extent to which the application of the first data protection principle and Section 6 would be likely to prejudice any of the following: the prevention or detection of crime, the apprehension or prosecution of offenders, and then they go on in a similar way to the FID, raising the issue of poker, tipping off Section 97 of poker. And they note that there are tipping off offenses, and then they conclude to avoid the uncertainty present in the United Kingdom and the Data Protection Act here, there needs to be some guiding notes, and they go on to say that it is suggested that the bill be amended to address the concerns raised and provide financial institutions with specific direction on dealing with internal relationship with respect to the money laundering legislation. And they would have spoken as well about exceptions or exemptions under this particular clause.
A suggestion, Chair, and it is based on the, particularly in relation to FID, and other agencies that are connected to government in that way, though autonomous. Because the explanation that you're given, I understand. I don't know, perhaps it would benefit the process if at the next sitting or before the next sitting there'll be some kind of, maybe a phone call, a conversation, just to say to them, listen, we hear this was the concern that you had raised as it relates to the functionality of this process in relation to your act. This is the explanation. We just want to know if you find it to be suitable, right? Or if you have any other concerns. I think that would help us moving forward so that we don't go through this process and then end up in a situation where we then finalize, and then still have issues with the several persons, particularly like that, who have raised matters which we consider to be treated with.
All right, member, were you going to respond? Okay, I just want to say, member, the Part 5, all of the clauses in Part 5 deals with exemptions, right, to the rights that we would have as data subject. And I don't know if it is that we would need to do the entire Part 5 to kind of get a sense of these exemptions, because if you look further on, you would see exemptions, law enforcement for law enforcement, taxation, statutory functions, etc. You see the exemptions for journalism, literature, and art. You'd see the exemptions for research, history, and statistics. Temporary exemption for manual data held by public authorities, and so on. So I don't know if we need to, it would appear to me that we would need to look at the exemptions in their entirety to be clear about what it is that FID is raising. Okay.
That's why we have the committee, right? And even though all persons are not here, we're here, we have the time, let's ventilate it, and even outside of here we can ask those persons who have responded with comments where I think, and the only reason why I raise it is because their issue relates to something that is very serious, you know, the gravamen of their capacity to execute their function in terms of you know, the matter of their investigations. And I would never want us to sit here and come to the conclusion that all is well, and then they have a different opinion, and we could simply have just asked a question. So it won't offend anything, it won't hurt us, you know. Let's move forward, we accept the clause, and accept the recommendations and then just ask.
Chair, if I might, one of the things, when the members look back at the written submission of the FID in particular, as maybe the only law enforcement type agency that actually submitted comments on the bill. One of the things that they were clear about is that they do see in the legislation provisions that could assist them or wouldn't detract from the work that they are doing. But they thought that there could be either greater clarity or there are elements of it that might prove problematic in the execution. And those they would have pointed out. But they were generally, in the beginning of their correspondence and their submission, oral and written, that the exemptions would cover them. They saw that they could cover them, but they thought that there could be greater detail in some respect. But their conclusion generally was that we need to just be exempted from this piece of legislation. That because it could cover us, and we see this as a little bit problematic, then just exempt. So, and I share that with the members so that we understand that there's an understanding of where they're actually coming from, that they're seeking full exemption. And while appreciating that in Part 5, there are some exemptions that would relate to them specifically and to any other law enforcement agency. So we take the point. We have no objection, certainly, as a ministry, sharing what our comments are in response to theirs and hearing back from them in relation to that. I don't know if the committee wants to necessarily meet with them and have them submit, or if it would be prepared to just hear back from the ministry in relation to what that conversation is. But that's generally the direction in which they were going.
All right, so for clause 32, okay, I think we have to wait for Currency to get back before I submit this clause. We can now resume. All right, just continuing where we were. Clause 32, I put it to the members to accept the recommendations from the ministry that the concerns of FID are adequately addressed. However, we take on as well Member Charles's concern that we go a step further and just ensure that FID is comfortable, that their concerns are addressed in terms of the exemptions that they're seeking. If there's no objection, we will move on to Clause 33, National Security, exemptions for national security.
So with respect to Clause 33, which essentially gives the minister with responsibility for national security the power to issue a certificate for the purpose of safeguarding national security, to exempt any personal data from essentially all the standards, the data protection standards. That would be all 8 of them, and Part 2, 3, and 6 of the bill. There were several comments from stakeholders on this particular clause. The Jamaica Chamber of Commerce noted that the exemption appears to be based on state secret and national security concerns and potentially separate processing, but we consider that the data security and fundamental rights concerns require more clarification to the circumstances in which a power would be, in which the minister would be exercising this particular power. FID also noted that the minister could issue a certificate, but where their concern was in relation to 33(4) in particular, which says that any person directly affected by the issuing of the certificate may appeal to the court against the issuing of the certificate. So their concern was that the fact that the certificate is subject to appeal and inquiry by the court may prove problematic, as the minister will have to provide reasonable grounds for the issuance of the certificate, and this would clearly be highly prejudicial to the work of the FID and to investigations which it is pursuing, and may also result in the commission of an offense under Section 97 of the POCA. NIDS also had a concern, and their concern here was with respect to, again, with the giving the Minister of National Security the power to exempt personal data from the jurisdiction of the Information Commissioner, purely on the basis of safeguarding national security. They were of the view that this position is not workable, and therefore suggested a re-examination of the clause. LAI felt that it was important that the minister indicate the motivation for each case in the interest of defense and public safety, and in that sense, discretion of the minister should be limited. It recommended that Section D of Clause 33(2), a new D be inserted, my apologies, that a new D be added, and that would read, duly inform of a motivation of the exemption from all or any of the provisions of the Act. So In response to the concerns raised by stakeholders, we in the research, we only saw a few countries that actually had any reference to the minister having a power to issue a certificate. That was Ghana, Singapore, and yes. So not many countries actually have this provision. But our comments generally were that the other acts broadly mention the need for exemption as it relates to national security, but do not, as the comments request, specify the circumstances under which the minister of public body will make this determination. So where in jurisdictions where the minister is empowered to issue a certificate, we didn't see any one of them that outlined why or how the circumstances in which the minister would be issuing these certificates outside of the broad issue of national security and national defense and public security. So the exemptions which fall within the category of national security, in our opinion, certainly are many and varied, and often involve highly sensitive information affecting intra-country operations or international relations. And for these reasons, it is not recommended that the legislation provides any further explanation of the circumstances under which such certificates or a certificate will be issued. With respect to the comments of the FID, and the FID's specific comments was around the fact that there could be an appeal against the issue of a certificate. We note that, but we anticipate that in the matters which are highly sensitive, such as those dealt with by the FID, the court will treat with the information and the proceedings in such a manner as to protect the integrity of the process. So that now falls within the remit of the court with respect to how they would treat with cases that come before them that have a national security leaning, or certainly national security is an underlying issue.
Chair, if I may, in relation to that last point first, this is consistent with another concept that we have in law, PII, public interest immunity, which can be claimed by law enforcement personnel, and it is used. And we have examples in our jurisdiction of the Minister of National Security in certain matters that are before the court, issuing a certificate that says it's a public interest immunity, so indicating that certain documents should not be released, and it's usually based on a national security exemption. And there is a lot of case law around how the court treats with those matters. But again, what is in clause 33.4 is just one way of showing that this is the way that we treat with these matters generally, that you don't just exempt the material, you allow for the court to inquire into it, and we understand and we repose some confidence in the way how the court will act and will exercise its jurisdiction. In relation to just the whole concept under clause 33, it is consistent with even principles under the Access to Information Act, where you not only have an exemption relating to national security, that act also allows in section 23 for, depending on who the minister is, it can be either the Prime Minister or specific ministers, and one would be the minister responsible for national security, to issue what is called a certificate of exemption. And in that act, it actually goes further to say that the court should not even inquire into that act. And we have used that certificate, and it has been presented before the court, and the court actually has given recognition to that. This whole concept of allowing for exemption for national security matters is not a new concept, not just in our jurisdiction, but in treating with maybe not data protection laws generally, but with how you access information and how you disclose information. It is recognized in a number of jurisdictions that you have to also know that there are certain things that need to be protected. But then you put a scheme and a framework around it to ensure that if it is inquired into and challenged in another way, we could then hopefully withstand that challenge.
Other countries like Ireland are recognizing the need for public security and national defense, but they do not speak to the issuance of a certificate, right? So it's the same formula, but a different mechanism to reach to the end. What do? If they don't have I'm trying to understand, what is the option if you don't have some particular person who can issue a certificate?
So I think generally what the regime across jurisdiction do is make exemptions for. So as we are treating in this part, exemptions in relation to national security, detection and prevention of crime, investigation, taxes, and so on. Each jurisdiction determines what it is that they're going to exempt from our data protection, from their data protection law.
The courts?
So while in here we would have said that there is no provision found about a minister being able to issue a certificate, what we're saying is that Ireland and maybe not the others, and every other jurisdiction that we have looked at has an exemption generally around national security issues or matters of but
so that's even wider than
that's
wider than what we're proposing.
So what you will see is language a little similar to what we would have said when we haven't gotten there yet, but that is coming in 34 about law enforcement, taxation, statutory functions, language like that, but not very many countries have adopted this particular certificate in addition to.
Let me tell you, why I asked the question is because I am anticipating the conversation that will come, because we have taken a stance that the word minister sometimes is almost seen as a bad word in legislation. It is unfortunate because it connotes a lot of things which really do not accord with our political democracy and our system, and the fact that at the end of the day, this person has reposed in them particular authority and responsibility, and it is also that person of whom is going to be strung up at the end of the day if something doesn't occur. So they really should be, and at times very well is the appropriate person to have particular authority. But I asked the question because I would like for us in ventilating this issue to have some kind of analytical comparison to see whether what other persons are doing, other jurisdictions rather, are how they are operating, whether it is better, right? So if it is that they just have the exemption but don't have any specific person, I wouldn't find that to be better. I find what we have here to be a more efficient process, where you have the exemption but you have the minister issuing a certificate.
So what our research finding would have indicated are the countries that we actually found a reference to the minister issuing a certificate, and I think that those were only 3 or 4 countries that have actually said it like that. What we have is almost a dual kind of scheme in relation to law enforcement and national security issues. We're saying, yes, there are provisions, clause 34 and so on, that give specific exemptions, but then we have added another element or another sort of another manner, another way in which to
added a certainty.
And that is through the minister. So, I mean, even while we were having a conversation earlier around whether or not FID could or would be covered by a clause 34, for example, this, and admittedly they said it would offer them some protection as well, because they could easily be one of the law enforcement agencies which the minister determined should be issued a certificate in relation to their work. Where their concern is the fact that it is appealable and can be challenged.
And then would expose the matter they're saying.
Right, but we would have heard the responses certainly from the SG in relation to this, and what we would have said as a minister, that we would anticipate that the courts would treat with the matter.
Yeah. This is the same court that deals with matters of great confidence and warrants and applications of such nature. So I wouldn't have much difficulty in that regard.
I would just to add, if the protection and exemption is taken care of in other clauses, what causes significance for the issuing of a certificate by the minister? If you're saying that it is already taken care of in previous clause, then what would drive you to go to that extreme?
Remember, it's difficult to determine what all the remits of this could possibly be once the legislation comes into force and we start to actually implement. What this is seeking to do is to ensure that there is a safety net for law enforcement agencies in the context of national security issues, so that if for whatever reason it is determined that 34, for example, doesn't apply to them, then there is some other scheme within the legislation that would offer them the ability to do their work that they need to do when they're considering personal data. So we certainly see it as added safeguard, notwithstanding that we think that 34 would cover a lot of what they do. It's added safeguard, because generally, as we were saying, the issue of national security usually is one of the matters that exemption across data protection legislation that would be exempted, within reason, of course.
All right, members. I put clause 33, exemptions that are granted to national security. We note the recommendations of the ministry that they're not recommending that the legislation provides any further explanation of the circumstances under which such certificates would be issued. If there are no objections, we'll accept clause 33. Okay? We'll take one more clause, clause 34.
So on clause 34, going into the actual exemptions now. Clause 34 treats with or makes provision for prevention and detection of crime, apprehension and prosecution of offenders, the assessment or collection of any tax or duty or any imposition of a similar nature, and provides exemption from the first standard. And members will recall that the first standard is in relation to the processing of the fairly unlawful processing of data, and section 6, which treats with the right of access by the data subject. So we have two comments, two stakeholders that have commented on this particular clause, the Jamaica Bankers Association and the FID. With respect to clause 34.1, the Bankers Association says that to avoid doubt, the list in this section should include an exemption for the reports or reporting requirement under POCA, as deposit-taking institutions are held under strict obligation of secrecy under those provisions, which may otherwise be compromised. It is also recommended that an additional subclause D be added which exempts confidential reports and information provided to authorities pursuant to the Proceeds of Crime Act or its regulations from the provision. With respect to FID, the note that the exemption what provided in this section is not absolute. The exemption is only to the extent to which the application of the first data protection standard, which is to process data fairly and lawfully, and section 6, which is the right of the data subject to access, is likely to prejudice the prevention and detection of crime or the apprehension or prosecution of offenders. They go on to say that the bill doesn't state who should make the determination of the likely prejudice, and this may cause a situation to arise where a data subject may seek to gain access to their personal information held by the FID, arguing that the requirements are likely to be prejudicial. There is no provision in the Act as to how this issue may be resolved. And the same, with respect to clause 34(2) and 3, they say the same considerations are highlighted. So their general concern here is essentially who determines whether or not the application of the first standard and section 6 is likely to be prejudicial to the purpose of preventing and detecting crime and apprehending or prosecuting offenders. In our response...
Sorry, Ms. Warren. Do you take it in the FID's comments, right? Am I to read it, or are you reading it rather, that they're asking for the actual determination of the person with that authority to be placed in the clause, that they want the person to be named out?
They're saying that there could be clarity around that, who is to make the determination. Our contention, though, and you'll see in our response, that we don't think it can be interpreted as anybody else but the data controller, in this case the FID, because they would be the ones that would be exercising within the remit of trying to detect a crime or prevent a crime or to apprehend a suspect. In the case of a TAJ, for example, or Ministry of Finance, they would be the ones that would be treating with tax and assessment. So it would, while a data subject might come to you with an argument like that, we would think that those data controllers in particular that have the remit of operating in these areas would be the one to say that it is my decision to determine whether or not something is prejudicial.
So you don't think it needs to be put in there that it's data controller, because it could be no one else? Or no logical, no rational reader could draw any other conclusion. So we're saying again, and this is the concern I have, because the FID is saying to you that they drew that conclusion. All right. Hey, I'm just saying. I'm just...
But remember, this is... I would like to give them the benefit of...
I'm not saying that you're rationalist. No. I'm just saying that at the end of the day, we already have the evidence before us that there is clearly uncertainty coming from persons with, I would assume, great acumen. Well, so is there some clarity that can be brought to it, or do you think it's not necessary and we want to continue to make it?
Yeah, well, with all due respect to the view that was put forward, whatever solution they might have in mind, which perhaps would be to specify that it's in the view of the FID, would cause more problems than solve. Because to put it that way would then, it could be interpreted that you're locking out, for example, the Information Commissioner or a court from inquiring into whether, in fact, the data is being processed for the prevention and detection of crime.
Go again? Could be
to include a provision here that
to make it clear that it's the data controller,
right,
would be to lock out other persons.
That could be interpreted as prohibiting the Information Commissioner or the court from really inquiry into whether it is in fact for the prevention.
So then we're saying it's
because
not,
it would then be indicating that the FID has the last word.
And just to add,
hold on. Take it easy with me. Let me try and understand. You're saying that could then be indicated that FID has the last word. Explain that part to me.
Well, if we were to add to the provision in A, for example, 34(1)A, that the FID has determined that the personal data is processed for any of the following purposes: the prevention and detection of crime, then it might be construed as prohibiting any inquiry by the Information Commissioner on the other provisions of the Act, which would otherwise allow the Information Commissioner to make a determination on an appeal brought by the data subject as to whether, in fact, the information should have been disclosed. It could be construed as prohibiting that or an inquiry by the court simply because we have locked in the provision that it is the FID who makes the determination.
As the data controller. So the concern that I have, that I'm sure you will clarify for me in 2 minutes that we have left here. The FID has made a submission in their comment that they would want to have a specification to make it clear. We are saying here, based on your analysis, the recommendation is there is no need to provide that certainty, that specification rather, because it is clear that it is the data controller. But then you're saying to me, no, that if we make it clear, it would prohibit persons other than the data controller. Is that what we're saying?
No, what I'm saying at least is that specifying that it is the data controller would not in fact make it clear. Because in the ordinary play of things, if a data subject is requesting information and the data controller says, no, you can't get the information because, then clearly that is the natural play of things. I don't see how it would need to be specified that the person who is requested to provide the information should be the one to say, no, because I can't provide it because of this. That is naturally what would occur. So I don't see, it seems a little deliberately obtuse for somebody to be requiring all of that to be spelled out in legislation. And again, we can't detail every possible scenario.
But if I might add to that, member, the chapeau starts in a particular way. It says in 34(1), personal data processed. In the context of the data protection bill, there's only one set of persons that can process, or a group of persons that process data, and that's the data controller. It cannot be anybody else but the data controller in the context of this piece of legislation. So it says, essentially what this is saying is that the data controller who processes data, without using the word data controller, the personal data where it's processed for these reasons, and they're only, we've highlighted a couple of those data controllers who would be processing for these reasons, most of them law enforcement agencies and of course our revenue agencies. And it just simply goes on to say, if you're processing for these purposes, then you are exempt from that first standard, that is to lawfully and fairly obtain information, and you have no need to disclose to a data subject that they have, rather, if they request, you have no reason to disclose that you have information on them because you are treating with these particular issues. So there is in our mind no way that a data subject could be dictating or determining whether or not something is prejudicial to them. because it is the processor that will say, I am processing for these purposes and I cannot give it to you. Then if they have an issue, they would have to take that on appeal or a complaint, and then the courts would settle that, or the commission, as the case might be. But we can't interpret it in the way that they've seen it, unfortunately.
Yes, takes a little digesting. All right, committee members. I put to you clause 34, exemptions as they relate to law enforcement, taxation, statutory functions, etc. If there are no objections, we'll accept clause 34. All right. For our next meeting, which is scheduled to be held next week? No. Next Wednesday at 2 p.m. sharp. We will begin at clause 35. We can only take it a little at a time. A weekend, all right. Pardon me? 16th. All right, next meeting will be the 16th of October, starting at 2 p.m. sharp. So I thank you, committee members. Next Wednesday. No, I've scheduled it. Let me end the meeting. Yeah? Okay. Check it. All right. Thank you to the members of the committee. Thank you, Office of the Parliamentary Council, Attorney General's Chambers, Legal Reform Department, Ministry of Science, Energy and Technology, the Houses of Parliament, our new committee clerk, who is standing in for Ms. Brandon, Ms. Grayson Morrison. See you next week. Thank you. The meeting is adjourned.